Welcome back. Thank you for staying with us here on SA Today. While corruption is one of the problems South Africa has to deal with many times, whistleblowers have come under the spotlight for their role in fighting the scourge. There's concern that they're often not protected after revealing sensitive information about corrupt activities in the public and private sector. This follows a former Trillian management consulting CEO, Bianca Goodson, who has written an explosive letter to Eskom CEO André about life after speaking up about corruption. The question we're asking now is, should whistleblowers be protected and rewarded? Let's find out from Osbourne Molatudi, employment law specialist at Molatudi Advisory Services. A very good afternoon to you, sir. Thank you so very much for availing yourself here on SABC News.
It's my pleasure, and thank you for being on your show.
You're most welcome. How does South Africa really treat whistleblowers generally? I mean, there is a view and a perception, and perhaps it is a reality, really, that whistleblowers are not properly protected. And as soon as they indeed do blow the whistle, the person or the people that they're blowing the whistle about get to know, who they are.
Well, to answer your question, I think we must first unpack the law that protects whistleblowers in South Africa. It's referred to as the Protected Disclosures Act, often referred to as Whistleblowers Act. And ironically, that law is about 11 pages. It has 11 sections, but it has created so much legal disputes and legal litigation. But in direct answer to your question, whistleblowers do deserve protection in terms of our laws, and not only the Whistleblowers Act, but the Constitution, so that there is an encouragement on employees and other persons to come forward to blow whistle on any act of impropriety or corruption in their workplace or elsewhere, so that we promote the culture of accountability, responsibility, and good corporate governance.
Yeah. Osbourne, let's talk about it practically, not necessarily just legally. Let's just say an employee does note, does see, does have evidence of something that should really be tackled and taken care of, but really thinks about it on their own employment status in terms of thinking, well, really, what's in it for me? If I cause trouble, I'm probably going to be out. If I speak out, I'll probably be out. What mechanisms, if I can put it that way, are really in place to encourage the blowing of the whistle for whistleblowers to, in fact, come out and speak without being seen as, snitches who would then, there'd be ways found to push them out of organizations?
I think the mechanisms are there. Unlike the Criminal Procedure Act, unfortunately, there's no physical protection that is offered. There's legal protection that is offered. And this is just to encourage employees to come forward. And as matters stand, there's no reward or gain. All what the employee needs to do is to make what is referred to as a protected disclosures. So in due course, probably the legislatures will look at amending the current law to make provision for a reward, especially where a whistleblower would have saved a particular company or even the state substantial amount of money through his or her act of blowing the whistle. And of course, the case of Bianca Goodson comes into play. But as matters stand, unfortunately, there's no provision for reward. It's just an encouragement for employees to come forward and make a protected disclosure. And there are requirements for one to earn that protection in terms of the Whistleblowers Act.
I want to talk about the repercussions, and pardon me for kind of moving on to a different case altogether, but it's something that played out quite recently, and I think it was in fact yesterday, where we saw Dudu Myeni speaking yesterday at the inquiry where she named a whistleblower whose name was not supposed to be out there in the public. This really did quite upset the Deputy Chief Justice, Zondo, who said that this should not be the case. Surely there should then be proper repercussions in place for a situation like that, where the name of a person who's supposed to be protected, and I would assume that Zondo was referring really to the Protected Disclosures Act, which you also referred to, that a person who is in fact a whistleblower should then indeed be protected. But in this case, where the name was put out there as it shouldn't be, surely we should see some sort of a repercussion for that having been done. Otherwise, more whistleblowers will say, you see, this is what happens when you blow the whistle.
Indeed, I agree 100% with your summation, and I think Miss Mieni has a lot to answer. She has been given until 10 a.m. on Monday to explain why she disclosed the name of the witness, and that is potentially a criminal offense matter, and therefore probably she will come up with a substantial explanation as to why she did what she did. In terms of the PDA, just to clarify, employees have a choice. They can either report acts of impropriety or corruption or related anonymously, or they can simply come forward. The protection that they deserve, it's against what we call occupational detriment. So in other words, as soon as they make a protected disclosure, they should not be subjected to a victimization, a demotion, or a transfer to elsewhere, or even be fired for that matter. That's the current protection that is there in terms of the PDA. The one that pertains to Ms. Mieni, it's in terms of the rules and regulations of the Commission, as well as probably the Criminal Procedure Act. And I'm sure she will be making her submissions in that consequence. But I do agree with you that there has to be repercussions where one has breached that order, that a particular witness remain anonymous.
All right. It was a pleasure speaking to you, and thank you for unpacking this information for us. Osbourne Molatudi, who is an employment law specialist. We really do appreciate it here on SABC News. Thank you, sir.